Hi, I'm Darshika, and I have been an IP trademark paralegal for over 7 years. I'm currently an IP paralegal at Uber, um, and I'll be doing a deep dive on selecting and preparing trademark applications today. So for an overview, I'll be discussing the trademark selection process, trademark searches, elements and requirements of trademark applications, filing strategies, filings with TEAS, which is the online trademark filing system, trademark prosecution timelines and life cycles, and intake forms. So let's get started. First, we're going to go over the trademark selection process, which I'll cover likelihood of confusion, strength of trademark, and other factors. First, I'm going to talk about likelihood of confusion. A trademark must be unique. It can't be registered if it's similar to someone else's mark. So you would do a likelihood of confusion analysis, which weighs numerous factors against each other, and it's outlined in the DuPont factors. So some of the things that you would consider is, does the mark look and sound the same as someone else's mark? So say if you were trying to trademark Coca-Cola with a K for soda, that would be too similar to Coca-Cola with a C for soda, and you would have, you'd probably have issues getting it registered because Coca-Cola would oppose your mark. But also you wouldn't get through the examination stage when the examiner reviews your trademark. And that also covers, is your mark being used for the same goods and services? So if you were to try to trademark Domino's or Domino's for pizza versus Domino's, and it's both for pizza, you won't be able to register that. Some other things that you should consider are they being used in the same marketplace, or does one mark have fame status? So everyone knows that Coca-Cola is used for soda. They're famous for it. So I would not try to name my new soda product Coca-Cola with a K. And then that would also cause confusion, which is another factor. Does the product cause actual confusion if you were to release it out in the world? So those are just a couple of things that you would consider when doing an analysis of likelihood of confusion. Next, we should evaluate the strength of the trademark. The diagram above is a good guide to figure out if your mark is weak or strong. Marks that are generic, like Band-Aid for bandages, and descriptive, like the Weather Channel for a channel on weather news, tend to be weaker. Whereas suggestive marks like Netflix, a streaming service for movies and for you to watch movies and shows online, are a little stronger than generic and descriptive, but a little weaker than a strong mark. And a suggestive mark is just a mark that doesn't exactly say what it provides, but it suggests it. And then an arbitrary mark or a fanciful mark are stronger marks. And an arbitrary mark is just using an existing word for your brand, but it has nothing to do with the goods or services that you provide. And an example is Apple for computers or phone. A fanciful mark is just a whole new word for your brand. So an example is Kodak for cameras. And both arbitrary and fanciful words are considered strong because they're both unique. So some other factors you should consider when picking a trademark is your trademark a surname? Is it geographically descriptive or deceptive? Is it disparaging or offensive? Is it a foreign term that translates into a descriptive or generic term? Is it a title of a book or a movie? Or is it a matter that's purely decorative or ornamental? These can be all factors that could make it really difficult to register your trademark. In some cases, like a surname, you could register your mark in a supplemental register, which we'll discuss later in the presentation. But in most cases, it could mean a very long litigation process or examination process. Next, we're going to talk about why it matters. Why does it matter to have a strong mark? Well, weaker marks are difficult to register. In most cases, you'll be going back and forth with the examiner on your, whether it's on cited marks or the description or just your mark as a whole. It's also more difficult to enforce for those trademarks, which in turn will also weaken your commercial strength if you're not able to enforce. And also, if you can't enforce, you probably can't stop competitors from using the same or similar marks. It's also a higher risk to be hit with an infringement suit. So you may be forced to rebrand, which could cost you thousands of dollars. And the last thing is that you can potentially be blocked from entering key foreign markets because there's already another mark in that key foreign market that can be cited against you. Next, we're going to talk about trademark searches. So we'll cover knockout searches, full searches, and trademark search opinion letters. So it's really important to do searches. If you don't do a search, you don't know what's already out there. You don't know if your mark is going to be confused with another mark. You don't know if there's a mark already out there that's similar to your mark for the same goods and services. So it's very crucial to do a search. And if you spend the money to do a search in the beginning, you save a lot more money through the trademark process because you know what you're up against and you can pick a mark that is more likely to register smoothly. So how do you do a knockout search? Well, knockout searches are searches that you can do on your own as well as utilize vendors for. If you do decide to do it on your own, I would start with a test search on the USPTO, which is just a database of all marks in the US. And then I would do a search engine search through Google, Yahoo, or Bing. And then I would proceed to also check the app stores to see if there's, say you are filing an application in Class 9, you want to see if there are other apps similar to yours with a similar name. And then, of course, you can use vendors like Clarivate and CoreSearch to supplement your knockout searches. And then as a tip, it's also very helpful to do common law and social media searches because not all third parties will have an app or a website for their services. Next, we have foreign knockout searches, which are crucial, especially if you are going to be expanding into other foreign countries. Without the foreign knockout search, there's a risk that you may not be able to enter key foreign markets. And I would start with looking at the European Trademark Office, as well as other individual country trademark databases, which can be accessible through the Country Portal and TMView. And then I would also check the global brand database on WIPO. So once a knockout search is done, it's recommended that you do a full search. It's just a deeper dive into things that you might find in a knockout search, and it will give you more information on third parties that may be a risk for you filing the mark that you want. So in the US, using vendors like Clarivate and CoreSearch can be helpful. And then for foreign full searches, you would reach out to foreign counsel and engage them to do foreign searches. And a tip is that for design searches, they can be really tricky. So if you're in-house, from a cost perspective, it would be better to just utilize a vendor to do your design searches. Next, we'll be talking about trademark search opinion letters. There's a couple factors that we should consider with opinion letters, which is pretty much a letter that you send to the client once you're done with completing the searches. First, you should always include an overall risk. It makes it easy for the client to read the letter, and it's an easy way for the business to decide, yes, we're going to proceed with this, or no, we're not going to proceed with this mark. So one way that you can do that is the point scale, and another is the percentage scale. An example of the point scale is listed on the slide, but 1 would be low risk and 5 would be high risk. So again, if we were to give a 1 in a search, the business would probably be safe to proceed with the trademark. If it was maybe a 3, then we would proceed, we would consider proceeding or slightly changing the trademark before proceeding. It might depend on certain cited marks that were found. So we might try to address those before registering, or we might just decide to go a different route. And 5, high risk, we probably recommend that the business don't proceed with the trademark and rebrand. The next part is just in your opinion letter, include identical and confusingly similar marks. So include any marks that might sound or look like the trademark you're searching. Include any marks that might be same or similar, but also cover the same goods and services that you're trying to use your trademark for. And a really good thing to include in this section is also the history or background of certain third parties that may pose a bigger risk. So if you know it's a really high-end large business that has the money to pay for litigation, maybe you don't want to go against them if you're a smaller company or medium-sized company and don't have the funds to defend yourself against them. So those are things that you would consider in this section. And then provide a recommendation, whether it's to use the mark or not use the mark. If you just did a knockout search, maybe you want to recommend that they do a full search before proceeding. If they did a full search and it was low risk, then you can tell them that they should proceed with an application versus high risk. You can ask them to rebrand or slightly alter the trademark so that it's not as high of a risk to proceed with an application. And what's the value to the client? Finding a mark that's strong enough that is easy to enforce and register, and also to make sure that you don't get sued for using a mark that is confusingly similar to someone else's. Okay, next slide. Next, we're going to talk about elements and requirements of trademark application. So we'll be covering the type of trademark, filing basis, the difference between TEAS standard and TEAS plus, specimens, US filing attorney requirements, and principal and supplemental registrations. Okay, next we're going to talk about mark types. There are 3 major mark types: standard, character, stylized, and non-traditional. A standard character is just a mark of words, letters, and numbers in any form. And below are some examples of standard marks for Caterpillar and Nordstrom Rack. Stylized is the same thing as a standard character, but it could have a design element or it could be stylized. But it's also a combination of words, letters, and numbers. And below are the stylized version of the standard characters I showed on the left side. So Caterpillar has a yellow triangle under the A, and Nordstrom Rack is double the size of Nordstrom. So both of those are considered stylized. And then lastly, we have non-traditional marks. This can include the Christian Louboutin heel, the red sole that they have on their heels, or the scent of Play-Doh, or the chimes of NBC. So it can be any shape, sound, scent, or trade dress. Next, we're going to be covering filing bases. There are a total of 5 filing bases. The first 2 that we're going to cover are maybe the most filed in the US by US companies. And in order to register your application, you have to assign a legal filing basis to each class in your application. So the first one is a Section 1A. A Section 1A is just if you're using your mark in connection with the goods and services currently, and you're trying to file a trademark application, this is the section you should file because you should be able to provide a specimen and a first use date, which we'll go more into later in the presentation. But you'll be able to show use when filing your application. A Section 1B is if you're not currently using but you intend to use, or if you're using and don't have a good specimen of use, you'd go ahead and file a 1B. Because at the time of filing, a specimen and first use date is not required, but you will have time later in the process to file a specimen and first use date. Also, if at any time you want to convert your 1B to a 1A, you can go ahead and do that by submitting a specimen and first use date. You can also file applications with both filing bases 1A and 1B, but your application won't proceed to registration until you have use for all classes. If at any time you have use for some classes but not others, you can file a request for dividing out the classes that you have use for. So those can proceed to registration, and then you can divide out the classes you don't have use for. So you can continue to take extensions to file your use for up to 3 years. So next we will talk about filing bases, Section 44D and Section 44E. If you own a earlier filed foreign application or registration, you can use these bases to file in the US. For Section 44D, you'll have to submit a copy of the foreign application, and for Section 44E, you'll have to submit a copy of the foreign registration. And the last filing basis is Section 66A, which is just an application based under the Madrid Protocol, which is a treaty that lets you have protection of your trademark in multiple countries. So say you file in the US, you can file a WIPO application based in the US and extend that application to various countries that fall under the Madrid Protocol. And a list of those countries are available on the WIPO website. Next, we're going to talk about TEAS Plus and TEAS Standard. Those are the 2 types of applications that you can file when filing in the US. A TEAS Plus application is cheaper than a TEAS Standard, but with the TEAS Plus, you can't customize your goods and services, and you have to submit both your fees and additional statements at the time of the filing. Whereas a standard, you have more freedom in coming up with a description of your goods and services, which we'll also talk about later in the presentation. But also you can submit additional statements after you've submitted your initial application. So there's just a little bit more freedom with the TEAS standard than there is with the TEAS Plus. Next, we're going to talk about specimens. A specimen is a sample of your trademark used in commerce. It's a real life evidence of how you're using your mark with the goods and services claimed in your application. It's what people will see when they're trying to buy your product or purchase your service. So some samples of specimens for goods are just like a photo of the product with the mark on it. The product container or packaging, a label or tag showing the good with the trademark, a sale display of at a store where your product is housed under the trademark, and then some examples of specimens for services are like online advertising or marketing material, just like a screenshot of the web page that you're providing your services or signage, or even materials that you use when you're providing those services. So when is a specimen required? When you file a 1A application, it's required during the time of filing. When you file a 1B application, it's required later on in the process when you file a statement of use. And again, you can change a 1B to a 1A by just filing a specimen before your application is approved for publication. And then for 44D and E, a specimen is required during the renewal stage. So between the 5th and 6th year of registration and the 10th year after it registers. Next, we're going to go into specific specimen requirements. The USPTO has all of these requirements on their website, but you're required to submit one specimen for each class. Although you're required to submit one specimen for each class, you should, at the time of filing the statement of use especially, make sure that you are using the mark in connection with all the goods and services, because it could put your registration at risk for cancellation. And the specimen should be a real example of how you're using your trademark. If you submit a mock-up or a digitally altered image, or how you want to use your mark, or a draft of the website, it will be rejected. And then the USPTO has specific requirements of like file type, or you should make sure that your trademark is shown with the actual good or services provided. Make sure that the drawing you submitted when you're filing an application is what the trademark looks like when you're actually using it. And then also, when you take a screenshot of a website, make sure the URL and the date that you access the web page is on the bottom in the footer or the header. There's also specific requirements as to how big the PDF should be, and those can all be found on the USPTO trademark website. So with the specimen of use, you are required to submit a date of first use. You're required to submit the date of first use anywhere, and that can be used by the applicant's related company, a licensee, or the predecessor in interest. And then second, you're required to submit a date of first use in commerce. So that could be the date of first sale or transport of the good in connection with the mark, or the first time you provided the service, but it also has to be in connection with the mark. And it can also be the first time you advertised your service in connection with a mark. But it must be the first use date in commerce that US Congress can regulate. So whether it's interstate commerce, territorial commerce, or commerce between the US and a foreign country. And again, the date reflected could be used but shown by the applicant or the applicant's related company or licensee of the applicant. Next, we're going to talk about US filing attorney requirements. So if you are a foreign domiciled trademark applicant, you are required to appoint and be represented by an attorney who is licensed to practice in the US. And if you are a US licensed attorney filing a trademark application, the form now requires you to provide all of your contact information, your bar information, including your bar number, when you were entered into the bar, and if you still have active membership, which is just a box that says, I confirm that I'm in good standing. Next, we're going to talk about principal versus supplemental registration. Principal registrations is usually protection for standard registrations and for distinctive marks, whereas supplemental registration is usually protection for marks that don't qualify under principal registration, whether it's due to descriptiveness, geographic descriptiveness, or if it's a surname. And if you think back on the diagram that shows if a mark is weak or strong, generic and descriptive marks usually fall under supplemental, whereas suggestive marks can be under principal as long as they might need a little more evidence to show that they're suggestive, but they can be registered under a principal, as well as arbitrary and fanciful marks can be registered under the principal registrar. Principal registrars also have additional benefits. You can base a Madrid application off of them. You can file an intent to use application under them, and you can record them with customs. Whereas for supplemental registrations, you can't do any of that. And instead of an ITU, you have to file a use-based application. Also, once a mark has been used for 5 years and has acquired distinctiveness, so over time, if the mark has been used enough and becomes popular enough, it can gain acquired distinctiveness and be registered under the principal registrar. Whereas supplemental registers only have limited protection, especially against confusingly similar mark. And there's no presumption of the validity and ownership for supplemental registers. Next, we're going to be talking about filing strategies. So filing strategies can depend on the company. It can depend on a couple of things like budget, what are your priorities for this year, how long do you want to use the mark, where do you want to use it in the world. There's a lot of factors that go into filing strategies for each company. So these are just some things that you should keep in mind when deciding. But of course, consider other factors that may apply to your business. So the first thing we're going to talk about is mark types. We're going to do a deeper dive into protection for each type of mark. As you may recall, there are 3 types of major marks: stylized, standard, stylized, and non-traditional. A standard character trademark allows for the broadest coverage. Say you are still working on your trademark and haven't finalized how it's going to look, but you want an earlier filing date, it's recommended that you file a standard character trademark, as you can use it in different forms and it will still have coverage through your standard character trademark. A stylized mark, you have to use it the way you file it. So there can be no more modifications. And if you file a standard stylized mark, it's also recommended that you file a standard character trademark for the broadest coverage. And you might eventually down the line stop using your stylized version, but if you have a standard character, you're covered for any new logo that you, or any new stylized mark that you might use. It is recommended that stylized marks be used for marks that may be too generic or too descriptive. It makes them stand out because they have the stylized aspect to that mark. So right under the standard character mark, I've provided 2 examples, Facebook being one of them. So on the left side is Facebook standard mark, and then in the middle is their stylized mark. Although the standard character mark for Facebook gives them coverage for the stylized version, they decided to file for both, I'm assuming because they use the stylized version a lot, and it probably helps them enforce in certain countries. And then last is color mark. So color marks are just standard marks and stylized marks, but they claim color. So when you're filing your application and you write your mark, there's a box that says, do you claim color? So if you select that, you can only use your mark in those colors. And if you do use your mark in other colors, the color mark that you filed for won't have coverage for that. So it's recommended that you file in submit a black and white drawing of your trademark, and don't claim color, and that will provide you with the broadest protection. So FedEx, surprisingly, they only have trademarks that are in color, but they've only used their marks in color. And then Caterpillar, they filed for their mark with the color yellow triangle above the A. And then Facebook also has protection for a specific stylized Facebook mark with the blue and white coloring claimed. Next, we'll talk about multi-class trademark filings versus single-class trademark filing. So in the US, there is no difference in terms of cost if you file multi or single, because each application is based on the number of, each filing fee is based on the number of classes you file. However, that might not be true for other foreign jurisdictions. In certain jurisdictions like the EU, you can file up to, I believe, 5 classes for the same fee. And so there's a couple reasons you would file multi versus single. Say you know that you're filing in 3 classes and one class might be difficult than the other 2, whether it's you have use for one class or 2 classes over the other, or you know that the business is ready to launch in certain classes over the other, or after going through the search process, you realize that you might get an objection for a mark in class 9, but not 42. Those are all reasons that you can consider when deciding if you want to file a multi-class application or a single class application. And of course, if you aren't sure and you decide to file a multi-class trademark application in the US, you can always request to divide out the classes that you're having issues with. That way, the classes you're not having issues with will proceed to the next stage, and the ones that you have issues with, you can address them separately, and you'll have a registration for something in the meantime. And then outside of the US, there are some countries that will only offer single class applications versus multi-class. So in those countries, you have to file single class applications. Next, we're going to talk about the Paris Convention. This is actually really cool because it gives you extra rights and IP. So the Paris Convention, it just provides cross-border acknowledgement of certain rights related to IP. There are currently 176 countries under the Paris Convention, but not all countries fall under it. And it's pretty much where you can file anywhere within 6 months of the first filed application to claim the same application date as your first filed. So say you are in the US and you filed an application on October 1st, you have 6 months from that date to file in any of the 176 countries, and you'll claim the date of filing as your US application. So say you decide to file in December, it will still give you the date of filing in October 1st, 2020. The only thing is, when you file that priority for filing, you have to claim just the goods and services that are in your original filed application. If you do decide to add goods and services to the new application, those goods and services will get the same filing date as the new application and not the first filed application. The only goods and services that will qualify for the same date as the first filed application are the ones that are in the first filed application. And it's good to remember that even though you are getting the same filing date, say you file in a different country, that country's examination process will still apply to that priority application. And each of those applications will register on their own timeline. So like examples are India or Mexico, they will still have to go through their own examination process in those countries, and they will be registered based on the timeline of that jurisdiction. And just a tip, if you are expanding into non-US markets, register in those jurisdictions as soon as you can. Unlike in the US, most countries are based on first to file the application and not first to use. So that pretty much means that you'll get rights the day that you file an application and not the rights that you won't get rights the date that you were using the mark. So if you were using the mark on a certain date, but you didn't file until 6 months after that date, you'll get that for enforcement matters or dispute matters, you'll get that date that you actually filed and not the date that you started using the mark. So it's important to file as soon as possible. Next, we're going to talk about filing SWTs. So I'm going to do a deeper dive into descriptions and goods and services, as well as disclaimers. Next, we're going to talk about creating a description for your application. So a description is just an explanation of the goods and services that you're providing under your trademark. So there are a total of 45 classes, 34 for the products or physical products that you are providing under your trademark, and 11 for the services or activities that you're providing. So tips to creating a description for a trademark application. There are class headings or niche classifications, which are descriptions that are accepted worldwide. And they can be found on the WIPO or USPTO website. Those are good to include, especially if you're going to file foreign applications based on your US application. It provides for broader coverage. And that can be really good for enforcement purposes, or if your business decides to expand, then you won't have to file a new application for the new services, because you might have a broad description that will already cover any new services that they decide to expand on. And it's also good to know that you can never broaden your description at any part of the trademark process, but you can always narrow. But the only downside with broad descriptions is that, one, you could get an office action because your description is too broad, and the office action will just require that you specify your description. And at that point, the USPTO has a trademark ID manual that you can use. It's just a manual of accepted descriptions by the USPTO. And then the second downside is cancellation. You are at risk for cancellation if you have goods or services in your description that you're not using. So make sure that before your application gets registered, that you delete any goods or services that you're not actually using. And then there is a case, Mendol Limited versus Neurovax Inc., where actually the TTAB took a really hard stance against, and they noted that the TTAB applicant should have known when they filed their statement in use that they weren't actually using their mark for all the goods and services. So the TTAB didn't allow them to amend to delete the goods and services that they're not using, but they canceled the entire registration. So it's always a risk if you have goods and services in your description that you're not using, to keep them there when your application registers, because the TTAB is taking a stronger stance against canceling those registrations. Next, I'm going to be talking about disclaimers. So a trademark disclaimer is just a statement that's made on record when you're filing your trademark application or during the process of your trademark application to indicate that the applicant doesn't claim exclusive rights to the disclaimed portion of the mark. And it's always printed on your registration certificate that you disclaimed that part of your trademark. So a disclaimer is usually requested when a trademark has one or more words that are merely descriptive or generic in relationship to the goods and services claimed in your application. So like Starbucks coffee, if they are trademarking their mark for coffee, they're required to disclaim the word coffee from their mark. And this disclaimers are just very important to prevent trademark owners from just gaining an unfair advantage of claiming a very descriptive and generic term. And it also clarifies what's not proprietary in a mark. So some examples are Ashley Furniture. Furniture is disclaimed from that mark. Coffee is disclaimed from Starbucks Coffee, and pizza is disclaimed from Domino's Pizza. And there's two places where you can claim a disclaimer. So if you want, you can file the disclaimer when you file your trademark application, but if for some reason you choose not to, the examiner usually will issue an office action asking you to disclaim that mark. And it's just a pre-populated box where you include the word that you were disclaiming. And this is the language on the slide is the standard language that is pre-populated when you select the disclaimer option and you include your disclaimer. Next, I'm going to go over trademark prosecution timelines and life cycles. So I'm going to go over the US timelines as well as foreign timelines. First, we're going to talk about the US timeline for a use-based application. First, someone will file an application and it will take about 3 to 4 months for an examiner to be assigned and examine that application. If the examiner has ID issues or they're requesting a disclaimer or there is other marks that are cited against that mark, they can reject it and issue an office action. If they do that, you have 6 months to respond. And of course, if you respond and that response doesn't resolve all the issues, they can issue another second office action response, which will delay this timeline an additional 6 months. But if they don't and they accept your response, the application moves to be published within 3 or 4 months. Once it's published, any third party can oppose your mark. They have 30 days to oppose your mark, whether they think that your mark is similar to theirs or they think that you're providing the same goods and services under the same brand that they might consider opposing. And once your application is opposed, you have up to 1 to 3 years for litigation purposes or settlement purposes. And once you go through that, if your mark still proceeds past that, it will register within 2 to 3 months. And again, if no one opposes your application, it will proceed straight to registration within 3 to 4 months. Next, we're going to talk about US timelines for intent to use applications. They have a very similar timeline to a use-based application, whereas they file their application. It takes a couple months for examination. It can get rejected. There can be an office action stage. If not, it gets published. Third parties have 30 days to oppose. If they do get opposed, there's up to 3 years of litigation and settlement. If they don't get opposed, they go to the notice of allowance stage. So this is the part that's different for intent to use applications. As I mentioned before, with a 1A application, you have to submit a specimen and a first use date when filing, and a 1B, you don't have to submit that until later on in the process. So with a 1B application, once a notice of allowance is issued, you have up to 3 years. So you have 6-month increments for up to 3 years to file your statement of use. So once the notice of allowance is issued, you have 6 months until the first extension deadline to file your statement of use, at which point you can, if your mark is in use for the goods and services, you can submit the statement of use with the specimen and the first use date. And if it's not, you can take an extension. And you can extend for up to 3 years. And once you do file your statement of use, an examiner will review it. Actually, the ITU department at the USPTO will review it. And if it proceeds to registration, it should register within 3 to 4 months. And if there is an issue with your statement of use, they sometimes will issue an office action asking for more information or a better specimen before they approve for registration. Next, we're going to talk about foreign timelines. So foreign applications can vary per country, and they don't necessarily follow a similar process as the US. In some countries, your mark can get registered before it even goes through the examination process or published before that process. So it really varies per country. The INTA country guide and the individual country trademark office websites are really good resources to find information on specific countries and their timelines. Also, if you file a WIPO application, again, your WIPO application is based on one application. So say it was based on the US and then it's extended to various countries that fall under the Madrid Protocol. Each country will go through their own examination process, even though it's a WIPO application based on the US. The only difference with a WIPO is if there are changes to the base application. So say the US application had some amendments to their description, that will reflect on all of the extensions as well. It might take a really, really long time for that reflection to happen, but it does eventually happen. And then just to know, most foreign countries don't require you to show evidence of use to obtain a registration. However, like with everything, you can be at risk for cancellation if you continue to use a registration without use, or you have goods and services in your registration that you're not using. It all depends on the country. Next slide. So a good way to kick off the process of searches and applications are intake forms. As someone who works in-house, intake forms are really, really good ways for the attorney and paralegal to collect information from the business about potential trademarks. Alt Legal has a built-in intake form in their system. So if you're in-house, you can use that form to send to people in the marketing and branding part of the business to get more information on like what product or service they're providing. And then you can use that form to loop in your outside counsel to review that information and then file directly with the USPTO through Alt Legal's toolbar. For law firms, you can also invite your clients to collaborate with you on the intake form and use Alt Legal's T's toolbar to autofill. It's a really easy form to use, and it simplifies the process between you and outside counsel and the business. Thank you all for listening to our training today. Again, as an overview, it's really important to go through the search process, not only for yourself, but if you're doing this for your client, to help them have a mark that's registrable as well as enforceable. And then as you're going through the trademark application process, come up with good descriptions and good specimens to make the process a little less tedious. And then use USPTO and WIPO and INTA as resources to get more information on specific countries and specific topics that will be really helpful to the trademark application process. Thank you guys all for coming today.